Good afternoon, everyone. We are super excited for you all to be here for this webinar on water resources and armed conflict. My name is Amelia Steffen, and I am an intern with the International Humanitarian Law Team, and I am very excited to introduce our guest speaker, Mara Tignino. But before I introduce her, I just wanted to give an overview of how the webinar is going to flow. We're going to start with a presentation and then transition into questions. The chat is open, so if at any time you have a question, please go ahead and put it in the chat. We do have members of the IHL team monitoring the chat. So without further ado, I wanted to introduce our guest speaker, Dr. Mara Tignino. She's a scholar on water resources and armed conflict, and she is a reader with the Faculty of Law and Institute for Environmental Sciences at the University of Geneva, as well as the lead legal specialist with WaterHub. So with that, I'd like to pass it over to Mara for her presentation.
Yeah, thank you. I would like to thank the Red Cross for the kind invitation. Can you hear me well? Yes, I see. Can you confirm?
Yes.
Okay, thank you. So it is a pleasure to participate in this webinar. Again, many thanks to the American Red Cross. I'm going to share my screen. So maybe I just would like to say a few words about the Geneva Water Hub, because we are a small institution, so maybe not everyone knows. The Geneva Water Hub is a competence center of the University of Geneva and the Graduate Institute of International Development Studies, and we focus on different dimensions on water, and I'm specifically focused on the protection of water during and after armed conflict. So my presentation will focus on water resources. So just already in the title, we could start a discussion just about the title, because water. When I talk about water resources, we could think about different kinds of fresh water resources. So of course we have rivers, lakes, but we have also groundwater resources that actually are the most part of freshwater resources. And also when I talk about water resources, so I refer to fresh water. So even if our health is a blue planet, only a small percentage of water is fresh water. Only 3% of this water can be used for human consumption, of course, but also agriculture or industrial uses. Then when I refer to armed conflict, I refer to different typologies of armed conflicts, including international, non-international, but also occupation. So it is three different situations under international humanitarian law. You have a different set of norms who apply, even if the trend under international humanitarian law it is to have a common legal frameworks for international and non-international armed conflict. This is not the outline of my presentation. I would like to share with you some of the features of current armed conflicts, how the armed conflict of present days are different from the past one. Then I will try to identify some linkages between water, international peace and security, to give also what is the scope of protection under IHL when we talk about water. And then the last 2 points will be more kind of recommendations or direction that we have when we talk about the relationship between water and armed conflict. So features of current armed conflicts, unfortunately, we can say that in all armed conflict, in every armed conflict, water is often a target of the conduct of hostilities. So when I say so a target, for example, we can think about military attacks against water facilities in installations like, for example, aqueducts or water or a water tower, or also the installations that are related to water, so that are in a kind indispensable for the running of water services. In this case, I think in particular about electrical facilities, but there can be also other kinds of damage to the access to water. For example, if there is the targeting of industrial facilities that are situated near water courses, this can have an impact on the quality of water resources and to the service of water to the civilian population. Water can be also a weapon of armed conflict. So here, for example, I refer to the use of dams, for example, as a weapon in armed conflict. We have several examples where we have the control of dams and the threatening to stop to close the gates of dams, or also the opening of gates that can threaten the population situated downstream, flooding their lands. Then another feature of current armed conflict, it is that warfare takes increasingly place in cities. So in past armed conflict, the wars were taking place mainly outside the cities, for example, in the countryside. But now, since the Second World War, it is increasingly taking place in cities, and now we can think, for example, to the cutting of water supplies in Damascus, in Syria, that for several months or days even, the fact that the population does not have access to fresh water supplies has a strong impact on their life. And then also the use of explosive weapons in densely populated areas, that has a strong impact on the access to water services. And in this context, I would like to already mention, and we can discuss further on this topic, of the reverberating impacts. So, for example, in cities, infrastructure are increasingly connected between them. For example, electricity and water, and then the fact of targeting, for example, electrical facilities has an impact to water, and then, for example, you have also an impact in the hospitals or in schools that are deprived of the access to water. Then challenges related to non-international armed conflict. So increasingly, the armed conflict are non-international. So this also raises the questions of the obligation of non-state armed groups. Then a fourth element is the protected nature of armed conflict. So increasingly, armed conflict lasts over a long period of time, more even several decades of armed conflict we have. So even in this context where water is increasingly used as a weapon or a target in the conduct of hostilities, we have also to remember that the water, even in these extreme situations, can remain as a tool of peace. In this context, I would like to mention an example that the Geneva Water Hub uses very often to illustrate that this potential of water as an instrument of peace, of the organization for the Senegal River, the ONVS, that continued to be used as a forum of dialogue between Senegal and Mauritania, even during the territorial conflict that took place at the beginning of the 90s. So even in these circumstances, given that water is often a shared resource, especially when we talk about international water course, the fact that there is an impact on a country, this has also an impact on the other riparian countries. So here in this slide also I talk about this separation between jus ad bellum and jus in bello, and here I refer to the fact that international humanitarian law applies in any circumstances. So it is not there is not the issue of the cause of the conflict. So even in the case, for example, that we have an armed conflict caused by water, that actually there are very few cases about this situation. In any case, international humanitarian law will apply. So there is a separation between the law that focus on the threats to international peace and security, and the law that applies during armed conflict. So let's now focus on the scope of protection of water during armed conflict. Here, I would like to mention that the law that is applicable to water as a resource and water as an infrastructure is different under international humanitarian law. I will get back to this in the next slide, but under international humanitarian law in particular, the additional protocols, we have in the first protocol two provisions dealing with the protection of the natural environment, but only the widespread, long-term and severe damage to the natural environment are prohibited under IHL. So we have a very limited scope of protection. And in the context of water infrastructure, so water installations, facilities and works, I will get back to this in the next slide. There is a wider protection. In fact, the object indispensable to the survival of the civilian population, and what it is called the installations containing dangerous forces, dams and dikes, are protected under IHL. So we have two different set of rules under IHL that protect water. Then also the issue of water infrastructure, water related infrastructure. So water infrastructure, we can define this kind of installations as those that provide water services to the population, and water related infrastructure that cover the infrastructure that are needed to bring bringing water to the civilian population. So again, here we can mention the electrical facilities, and some of them can be indispensable for the functioning of the water infrastructure and for bringing water to the population. So in this case, I would argue that the water-related infrastructure like electrical facilities can also be covered under the object indispensable to the survival of the civilian population. Then, of course, also under IHL, there is a protection of the humanitarian personnel working for the rehabilitation and the repair of water infrastructure. So, for example, the engineers must be protected to ensure, for example, the repair to a water infrastructure that is damaged by the armed conflict. So under IHL, no, we can we have the general principles of international humanitarian law that protect water as a civilian object. So we have the principle of distinctions that is an obligation for the parties to an armed conflict, always to distinguish between civilian object and the military objectives. So only military objectives can be targeted during the conduct of hostilities. Proportionality. Proportionality means that in the case of also targeting a military objectives, the military forces must take into account what we call the collateral damage to the civilians and the civilian objects. And here, for example, we can think in the case, for example, of an industrial facility that is only used for the armed forces. If, for example, these facilities situated near an international water course or a groundwater resource that is used for providing water to the civilian population, there must be a calculation of the damage that also can be caused to the water resources. And then also the obligations of precautions, so the obligation to take a precaution to spare the civilians during the conduct of hostilities. Then we have the special protection on water, what we call as under IHL as a special protection of some specific civilian object like water. So here we have two provisions that are affirmed in both the first and the second additional protocols. So they must be respected during international and non-international armed conflict. So the protection of the water installations is covered under the object indispensable to the survival of the civilian populations, and also there is a specific protection for the works and installation containing dangerous forces like dams and dikes. Of course, no, these provisions are very important, but still, as I mentioned at the beginning of my presentation, water is always a victim of armed conflict. And when water is a victim of armed conflict, it is the civilian population that is targeted. And so here, my last two slides, it is really what we need what we need to progress to ensure a better protection of water and the civilian population, that it is not to consider the protection of water before, during, and after armed conflict. So what does it mean? It means that international humanitarian law, of course, we always think IHL as the body of law that applies during armed conflict, but actually there are also obligations that are in place during peacetime, and I will get back to this in my last slide. So, for example, the training or the dissemination of IHL is an obligation that it is also in place before an armed conflict. During an armed conflict, so the obligation during the conduct of hostilities, and after armed conflict. So, for example, I have the illustration of peace agreements that needs to include also water, and actually there are only few agreements that have a specific provision on water. And then also an important element can be the designation of protected areas that actually it is also important before in the phase before the armed conflict. So, for example, states can and also non-state armed group can establish by agreement some protected areas around particular water ecosystems or infrastructure. Then there is the issue also of the multiple legal frameworks. So we here until now we have focused on the obligations under international humanitarian law, but there are also other areas of international law that can apply. So the first one that we can think about it is the human rights law. So under human rights law, we have also the recognition of a human right to water that is it has been recognized through several resolutions of the UN General Assembly and the Human Rights Council. And of course, there are also other human rights that can be affected by armed conflict, like the right to health or the right to food or the right to life during an armed conflict. And then international water law. So international water law, it is that particular field of international law that applies to the uses of international water courses or transboundary water resources. And here we have some examples, very few examples actually, of agreements that also make a specific reference to international humanitarian law and can contribute to protect water resources. And then the third point, it is that under international humanitarian law, but also human rights law, water is not really protected for its own value, but also in relation to the environment or to the human population. But increasingly, under international law, there is this discourse about the rights of nature. So the rights of nature, there are also the rights of water in itself. So a question can be how the rights of water in itself can also be used as a tool for reinforcing the protection of water during armed conflict. So how a point that it is often raised in any discussion on international law, it is how now we can ensure implementation of this of rules of international law, especially during armed conflict. So here now there are some suggestions that also recommendations that with the Geneva Water Hub also we are trying to promote. It is not the fact to incorporate rules protecting water in military manuals, and actually there maybe military manuals can also include other bodies of international law, like for example human rights law, but also environmental law. Then the training, so it is very important to include in the dissemination activities or trainings also the knowledge on the rules of protecting water. Then something that can be more used, it is the human rights mechanism. For example, the Human Rights Committee established under the International Covenant on Civil and Political Rights, or the Committee on Economic and Social Cultural Rights, how we can use this mechanism to also address the protection of water during armed conflict. And of course, also another instrument, another mechanism can be international criminal law, and how not to use to include the water, for example, also protection of water among among war crimes. So here I conclude, and many thanks, and I look forward to the discussion.
Thank you so much for that presentation, Mara. It was very insightful and gave a lot of really interesting background on the issue. We have quite a few questions actually from the audience, so I'm going to go ahead and get started with those. And so first off, I'm just going to go down the list in the order that they came in, but the first question was, are these attacks, when conducted by government on water systems, considered violations of IHL?
So as I mentioned, no, under the first protocol and the second protocol, no, there is a prohibition of intentional targeting of water facilities, and also, no, in the case that there is a targeting of a military objective that has an incidental impact on water, here no, it will come into play the principle of proportionality.
And so to follow up on that, since water is used by both military millions and civilians alike, particularly in urban areas, how can armed forces comply with the principle of distinction?
So actually, no, there are only few cases where water is only used by the armed forces, and if you see, no, the commentary to the additional protocols, no, it is really no written that not this no no, it will be really difficult not to have an installation that is only used for armed forces. In the case that is used only for armed forces, it could be considered as a military objective, but there must be evidence of this.
Okay, so generally, when you're in urban areas, the water infrastructure is just not considered military objectives. That is how the principle of proportionality is effective in that sense in the urban areas, because they are just considered a civilian infrastructure. Would that be correct?
Yes. Yes, also because, no, as I mentioned before, no, there is the issue of the interconnection between the infrastructure. So there is no water, electricity that are interlinked, and also there is the connection of, for example, no, to hospitals, schools, agriculture. So everything, no, is connected, and it would be not. It is not very difficult, no, in urban settings, not to make this distinction. So the impact on the civilians will be inevitable.
So going along with that infrastructure, the connection of all the infrastructure and everything in urban areas, I kind of have a question about the strength of the water infrastructure. In areas that have really strong water infrastructure, does that help prevent the effects of conflict on it, or are there just aspects of water infrastructure that no matter what, if there is conflict, they will be affected?
Could you please reformulate the question? I'm not sure.
Sure.
No.
Yeah. So since in urban areas, water infrastructure is often there are consequences on the infrastructure due to armed conflict. Does the strength of the water infrastructure help prevent harm to the water resources in the area, or there are just some aspects of when it comes to armed conflict that though they will always, water resources will always be affected?
No, the fact I mentioned no, that now armed conflict lasts in general no, over years and decades. No, I remember no, with my colleagues, there was the examples that if at the beginning of the conflict it was targeted water installation, then no, the humanitarian personnel no, can go repair and can do this quite quickly. But then if there is again another attack, no, the infrastructure will be weakened, so it will be much complex not to repair. And you can imagine when the conflict lasts over decades, there is increasingly the difficulties of repairing. This is also no recommendation. It is for, that is often made. It is not to increase the resilience of water infrastructure. Now I'm not an engineer, so I don't know how exactly this can work, but I understand that over the year, it becomes increasingly difficult to run the wash services in a way that really can go to the population.
Yeah, that makes a lot of sense, because I can imagine in areas that experience prolonged armed conflict that it is very hard to fix and reestablish water systems that are very strong, especially when you have continued conflict going on. So another question from the chat is, the increase of water height in the Pacific Ocean due to global warming, could acts of mass pollution by large-scale polluters be considered as an act of war by countries who are the most severely impacted by climate changes?
I think that this is a little bit outside the topic. So I think that in the case of the global warming and the effects, for example, with the rising of the sea level, there can be the impact on the access to water, for example, the salinization of water resources, and this can affect the human right to water. Then to make this the link to an armed conflict, it is very, very difficult. I would link this maybe with the displacement of the population, but really the chain here become very, very long, the chain of causation.
Okay, so this is that example perhaps might have more of a link just with like human right to water than necessarily with armed conflict. So I know that in the presentation you touched upon it about enforcement mechanisms, but there was a question in the chat in regards to enforcement, and if you could expand on what enforcement actions could help ensure water resources are better protected during armed conflict.
So I would say that in general in international law there are two avenues. So the state responsibility, individual criminal responsibility. So, for example, in the case of state responsibility, states can bring cases before the International Court of Justice, and actually, there was a case between the Democratic Republic of Congo and Uganda, where one of the issues was the control of the Inga Dam. And there was among the questions raised if the control of the dam could amount to a violation of IHL. Actually, no, it would be difficult really to demonstrate that only the control of a dam constitutes a violation of IHL, because one of the conditions it is also that it causes severe losses among the population. So this can be an avenue. The International Court of Justice maybe can be used more in this case where there is the issue of state responsibility. Then, as I mentioned, there are the human rights mechanism. So, for example, there can be an investigation commission, a fact-finding commission established by the Human Rights Council that goes to investigate the violations of IHL and human rights law. And in some of the investigation reports, there are examples of attacks against against the water installations and the impact on the civilian population. Then the other way, it will be the individual criminal responsibility. So here now I refer to the Rome Statute established in the International Criminal Court, and among the war crimes, there are, for example, the crimes against the environment. But here, again, it is used the language of the first additional protocol, so long-term, widespread, and severe damage to the environment. And of course, since it is a criminal law, there is the requirement of mens rea, so of the intention to damage the environment, or also the access to services, to water services. I hope that.
Yeah, that was perfect. That was excellent. And I do have kind of a follow-up question for at the end you were talking about the environmental protections for widespread, long-term, and severe. And I was just curious if you could give an example of what is the current legal interpretation of widespread, long-term, and severe, or rather, what sort of damage with water resources would rise to the level of meeting the definition of widespread, long-term, and severe.
Mm-hmm. So now I would like starting now to mention that the International Law Commission has developed some draft principles on the protection of the environment in relation to armed conflict. So here, you in this document you can find really the last thinking about the protection of the environment before, during, and after armed conflict. And I think regarding also the latest interpretation of the IHL rules, also the International Committee of the Red Cross has published the guidelines on the protection of the natural environment that are a set of rules where you can find really how not to interpret the different provisions of IHL, including the general principles. So of course, not these terms were used in the 70s, when it was negotiated, they were negotiated the additional protocols. I think that today these adjectives must be read, interpreted in the light of the current concern around the environment. So, for example, in this context, we could also think about climate change, or also what does it mean pollution today, and not in the 70s. And I think that it would be important also to consider the impacts on the health. And actually, one of the two provisions on the environment included in the first additional protocol makes a specific reference to the health of the population. So, for example, in this relationship must be interpreted in the light of the current concerns, but not only concerns, but also the scientific knowledge that we have today about the risks and impacts on the environment that we didn't have in the 70s.
So I guess kind of a follow-up question, and I feel like you may have answered this throughout going through the enforcement, but when it comes to effectiveness of all the enforcement mechanisms that you have mentioned, the courts, and also do you believe that they are effective, and what changes can we make to make them more effective, such as you just mentioned, kind of reinterpreting the meaning of widespread, severe, and long-term to fit the current issues that we're having? So how could we make these enforcement mechanisms more effective?
So I think that in the case of, for example, of the International Court of Justice, there is the possibility when one of the parties does not respect the judgment to go before the Security Council. And the Security Council can enforce the judgment. But actually, this avenue has never been used until today. I think that when we go to the judicial mechanism, it is we can say that it is like the starting of a process that from there, the states can be coached in a sense not to implement the judgment. For example, also the UN Secretary General can play an important role for enforcing, implementing the judgment of the ICJ. And this was the case, for example, in a case between Nigeria and Cameroon, where there was the issue that some territories were declared not anymore under the former state, and the UN Secretary General helped the country to ensure the implementation of the judgment, and also to protect the population that changed the sovereignty of the state. So to ensure that the state ensuring now that the sovereignty of this part of the territory ensure the respect of also the human rights of the population. So I think that the UN Secretary General could play really a role, maybe a major role in helping the implementation of the ICJ judgments.
Interesting. So going off of that, actually, how does the international community ensure that non-state actors respect the international humanitarian law obligations in practice?
Mm-hmm. So here now I would like to share the examples of an organization here in Geneva, the Geneva Call, that has developed what it is called the seats of commitments, where not the non-state armed actors take the commitment to respect norms of international humanitarian law. So in some cases, no, the fact that non-state armed actors take no the commitment to respect IHL can also serve its objectives if we look this in a self-interest manner.
That's very interesting. So, and I guess kind of a follow-up to that, but we're focusing back on state militaries. How can militaries do a better job ensuring their soldiers understand the importance of water resources and infrastructure and respect the IHL rules that protect those resources?
Yes, I think that it is very important that in the training of the armed forces and the dissemination activities, also this webinar be useful not to bring this issue of water and the existence of rules protecting water during armed conflict, and I think that really something key that I would like that all the participants also of this webinar retain, it is that protecting water, it is protecting civilians. So when we talk about water, it is that we talk about protecting the life of the population. So sometimes water, it is understood, okay, no, yes, we protect water resources, or we protect the water infrastructure, but at the end it is not for, it is for the benefits of the population. Then a second layer can be also to protect the water for its own value. That as I mentioned, when we think about all the discussion about the rights of nature, it is also that the first, I would say, the first argument, it is to protect the civilians, but the second one, it is also to protect the water for its own value. And no, we must not forget that water, for example, it is at the heart of many religions. So there is also these dimensions of water that must not be forgotten.
To pick up on the human right to water, you mentioned it a little bit in the presentation, but I was just wondering if you could expand a little bit on the human right to water, perhaps where it's found in different treaties or obligations, and then just maybe touch upon, like I said, you kind of have, but touch upon how the human right to water kind of changes the way that you view the protection of water.
Mm-hmm. So the human right to water, it was the first time that really we have this express recognition. It was in 2002 with the General Comment number 15 adopted by the Committee on Economic, Social and Cultural Rights, and the committees of rooted that is right on the right to health and the right to decent living conditions. And it is interesting that in this document, there is an explicit mention of international humanitarian law, and the committee refers to the Geneva Conventions and the additional protocols as evidence of the existence of the right to water. And then in 2010, so we have the first two resolutions adopted by the Human Rights Council and the UN General Assembly. So here, no, I should say, no, that the human right to water is limited to the personal and domestic uses of water. So it is not all the uses of water that are protected under the human right to water. And for example, no, in the context of the armed conflict, there is, for example, a clear link between the right to water and the right to food, because in the case of IHL, so only water necessary to prevent starvation would be protected. But in the case of the human right to water, we expand this protection. And also, no, we can bring together the right to water and the right to food. So for the protection, no, of the for example, the farm, no, that the subsistence of the population. And then there is, no, also the fact that through the human rights law, you have this not only the expansion from the point of view of the substance of the protection of water, but you have, for example, a set of procedural requirements that can be particularly helpful if we have this temporal approach on the protection of water, no? Because if we think, for example, on water after armed conflict, human rights law can bring all the aspects related to the access to information, transparency, the fact the population must have information on the quality of water, for example, not to prevent disease. So all this set of procedures are related to human rights law and to the right to water. And then no, there is also the third aspect. It is the access to all the human rights mechanism. So I mentioned some of the human rights treaty bodies like the Human Rights Committee or the Committee on Economic, Social, and Cultural Rights, but there is also the Universal Periodic Review with the Human Rights Council, and then also the regional human rights mechanism. So we have the European Court of Human Rights, the African Court of Human Rights, and the Inter-American Court of Human Rights. And it is interesting that, for example, in the case of the jurisprudence of the Inter-American Court of Human Rights, there have been explicit mention to the human right to water, specifically for indigenous peoples. So I think that really, human rights law can expand the protection of water in different direction.
Yeah, that is really, really interesting. I have thought about, it's just really interesting to see the layering of the human right to water, the IHL protections, and also just the rights of nature, the protecting water for the value of itself, all layered on top of each other, and how they can really expand the protections and how they are different lenses to look at the protection of water. So we have just a few more minutes and a couple more questions. And so I think the next question would be, would the deliberate poisoning of a country's water supply trigger an armed conflict under IHL, in your opinion?
No, as I mentioned, so there is a separation between jus ad bellum and jus in bello. So whatever it is, the reason IHL applies. And no, I forgot to mention that one of the oldest rules of international humanitarian law is the prohibition to poison, to use poison, and so to poison water resources. So it is really one of the oldest rules in the battlefield.
Oh, wow. That is really interesting. So next is the 1979 Convention on Long-Range Transboundary Air Pollution applicable in conjunction with IHL? And if so, how would the provisions apply and the parties be held accountable if they are signatories to that conventions, but not to additional protocol 1 or 2?
So first issue would be not to look at the convention and see what it says about the armed conflict. Now I don't remember the provisions of this convention, but there are conventions that explicitly say that are not applicable during armed conflict. So however, no, in the case of a multilateral convention, so where we have several countries, and then only two that are parties to an armed conflict, of course, the convention will remain into force for this for these countries, and then in the case where the convention does not a treaty does not contain a specific a specific provision on armed conflict. Again, there is the work of the International Law Commission that has developed some draft principles on the effect of armed conflict on treaties, and the environmental treaties and the treaties on international water courses are explicitly mentioned as treaty that will remain into force during armed conflict. So I would say that only a minority of treaties are explicitly contain explicit provision that suspend their application during armed conflict.
Awesome. So for our last question, I wanted to we have a question here kind of bringing it back to current events. So with regard to the Ukraine conflict, have you seen reports of attacks against water supplies or water infrastructure that concern you and are possible violations of international humanitarian law?
Yes, of course, I have concern about the violations of IHL rules in this regard, so not only regarding the water installations, water infrastructure, what we have called, but also the water resources. So the pollutions of international water courses. And I think that before February, actually water services were among the few issues where the water engineers could go through the line of contacts to repair the water installations, because on the two parts of the line of contact, the communities were relying on the same installations. So there were the two parties realized that there were a common objective to protect these installations. So yes, I'm concerned about the violation of IHL regarding water.
Well, that is really interesting. And also, I think just interesting to keep an eye on as everything progresses. But that was our last question. That's all we have time for today. I want to thank you so much, Mara, for taking the time to be here with us today. It was absolutely excellent, really interesting. So thank you so much. And thank you to everyone who attended. We really appreciate it. And we hope that you found this very insightful and super interesting as well. So thank you, everyone.
Thank you, everyone. Thank you. Bye.
Thank you. Bye.